Fourth Circuit. We're only able to do this morning because of our fabulous IT staff and clerk's office. So I want to make sure the entire panel wants to thank all the staff behind the scenes that are supporting us and making this possible today. So we're ready now to hear argument in our first case, Cedar Coal Company versus the Director of the Office of Workers' Compensation Programs. Mr. Kawash, when you're ready.
Yes, I am, Your Honor. Thank you. Can you hear me okay if I stand here?
Yes.
Okay, thank you. Good morning. May it please the court. Your Honors, my name is Michael Kawash with the Charleston, West Virginia law firm Robinson & McElwee, and I represent petitioner Cedar Coal Company. And I'd like to thank the court for permitting me to cover for my colleague, Mark Grigoracci, and present oral argument on behalf of our client. Mr. Grigoracci has prepared and filed the briefs on our behalf, and I think he's done a superb job in that regard. And I only hope that I can expound on them and answer any questions the court may have today. This case is about limits. The limits Congress and the Department of Labor have placed on evidence in black lung claims, and the limits of deference when an ALJ credits a medical opinion that is legally flawed, internally inconsistent, and contradicted by the record. The Benefits Review Board affirmed an award of benefits that rests almost entirely on Dr. Leonard Goh's opinion, an opinion that should never have been admitted as written and that cannot, even if admitted, constitute substantial evidence of legal pneumoconiosis. So I'd like to make 3 points this morning. The administrative law judge committed reversible legal error by admitting Dr. Goh's reports in violation of the evidentiary limits. The finding of legal pneumoconiosis is unsupported by substantial evidence because Dr. Goh's opinion is unreasoned and the contrary medical evidence was improperly discounted. And without legal pneumoconiosis, the causation and disability findings necessarily collapse. Your Honors, this case is characterized by a serious
So let me just lay out what I think is your argument. As I understand it, you think that Dr. Goh's reports should not have been admitted because Dr. Goh reviewed and assessed some other medical reports. Is that correct?
That is correct.
Okay, well, so how aren't treatment records and those other reports
Judge, you're breaking up. I wasn't able to hear that question.
Yeah.
I guess that explains why everybody was staring at me. Can you hear me now?
We can hear you now.
Yes.
I thought it was just a really stupid question. Okay. I don't remember what it was, but I think I was trying to lay out what your argument is. And you agreed with me, but aren't medical records and the treatment records that Dr. Goh assessed, aren't those affirmative evidence that are admissible?
Well, they're admissible within numerical limits. Under 20 CFR 725-414, a claimant is permitted no more than 3 affirmative pulmonary function tests in a modification proceeding, and that limit is mandatory.
But what about 414A1 and A2 that says medical reports may consider available admissible evidence, including any treatment records that are admissible under A4? Okay,
but if they're treatment records, then they cannot be this part of the affirmative evidence in the case. So here Dr. Goh's reports.
Yeah, they can. It says right here, treatment records are admissible, notwithstanding limits on affirmative evidence. Did your expert not review any medical records?
Yes.
Or treatment records?
Sure, they did, but with respect to pulmonary function tests as affirmative evidence, Dr. Go included 9 separate pulmonary function tests. His report of
Because
in
it was a
April-
part of the history of the treatment of the patient. Was Dr. Go supposed to ignore part of the medical history of the patient?
Well, the problem with this is that he provided his own analysis and interpretation of each test.
What he
It's not
provided
a
was an
matter-
assessment. An assessment is what he provided.
Okay, but he testified that he reread, he reinterpreted, and he relied on each
Was he not
test.
supposed to, in providing his medical report and expert opinion, you're faulting him for rereading the medical history of the patient. Was he not supposed to read those?
Well, it's not that he wasn't supposed to read them, but there's a limit on how many can be included in the record as affirmative evidence. A treatment record is the treating physician's interpretation. Dr. Go is not the treating physician.
Right, but as the treating physician, excuse me, as the expert witness, he can certainly refer to the treating record, the treatment record. I mean, what value would it be having an expert who was walled off from portions of the treating record in giving his or her opinion? Where's the logic to that?
Well, his independent interpretations caused the number of PFTs, the pulmonary function tests, to be exceeded by the rule. You can only include 3 PFTs.
Well, that goes back to my question earlier. When you have an expert that is to review the medical reports and treatment history of the patient, you're saying they can't review the entirety of the medical history and patient records. That doesn't make any sense. Is that what your expert did? Only look at part of the treatment history?
No, they looked at the entirety of it, but they didn't. But the employer didn't add more than 3 PFTs using one doctor or one expert to circumvent the rule that limits and caps at 3 in a modification proceeding the number of pulmonary function tests that are permitted.
Well, isn't the purpose of the rule that you're relying on to limit what the parties present for purposes of litigation? In other words, tests that are performed for purposes of litigation as distinct from the treatment record?
Yes, Your Honor, but also it's also to put a limit as to the weight of each party's evidence too, as well.
I'm sorry, say that again?
Well,
To
it's-
limit the weight of each party's, I don't understand what that.
Well, to limit the
Explain that.
numerical, I'm sorry, to limit the numerical weight of, to put a limit on the number of reports that an ALJ would be reviewing, I'm not sure this court would want to be reviewing an evidentiary dump when one expert is used to include all of these reports.
So what do you do in A2I? There, a portion of that has what I think of as an integration clause, and it says in effect that any PFT results and the physician's opinions that appear must be admissible, and then it gives us 2 choices, right? Either under this paragraph, right, which is the A2, which is the 3 limit that you've described, or A4. And A4, as Judge Thacker has pointed out, is obviously the treatment records. In contrast, as Judge Keenan pointed out, the evidence that's being submitted as part of the litigation strategy. I take you to think that this is a typographical error because it gives 2 different options. And so you think A4 is somehow limited by A2 despite this language? Can you help me understand that? Why do we read the or out of that and instead call it and?
Well, A4 concerns records of a hospitalization,
Or medical treatment.
Right.
So
or
a
treatment.
PFT for medical treatment, right, would be part of the treatment records. And so as many of those as were needed to actually treat a sick minor are admissible under A4, right? If it's 100 of them, I don't know why it would be, but if it was 100, they would all be treatment records, as Judge Thacker's pointed out. And so that's a separate methodology. And the "or" in this integration clause suggests to me that A4 is in no way limited by A1. And so I guess I'm having a hard time just understanding from the text why you think we ought to read that integration clause out.
Well, because A1 is very specific in its limitations, and it addresses particular types of reports: chest X-ray interpretations, pulmonary function test results, blood gas studies, autopsy reports, biopsy reports. So it puts a limit on
So
those
you
specific.
you think none of those things fall under A4? So A4, so your read is that the reports of related to medical treatment cannot include any of the things you just named. So when A4 says include all the reports, notwithstanding the limitations in A2 and A3, any record of medical treatment may be received into evidence. You think that there's an exception there for any of the things you just named? That is, all of the medical records, all the things that you say are identified in A1 that would be records of medical treatment. And despite the reference that it says notwithstanding the limitations of A2, you think those are just not treatment records that the ALJ can consider? I will confess, I don't begin to understand your argument.
Okay, well, as affirmative evidence, they're treatment records. They could be treatment records. In this case, what Dr. Go did, it's not a treatment record. His report is not, and a medical report cannot bootstrap an independent interpretation of objective tests. And so,
Why is that? Right? The medical report can consider admissible evidence.
because of A1.
We just said under A4, these are all admissible evidence.
Well, A1, a physician's written assessment of a single objective test, such as a chest X-ray or PFT, is not a medical report.
And did Dr. Go's report address a single objective test? Or did it address a bunch of tests and a bunch of information?
Well,
I mean, just help me understand. Does Dr. Go's report address only a single record?
it addressed 9 single objective records.
That's not even true, right? That's not the only thing it did.
I'm sorry.
That's not the only thing it did.
Well, to the extent that it exceeded the affirmative evidence limit, it did. And it's our position that he exceeded the medical evidence or the affirmative evidence limit for pulmonary function tests. And it would gut the evidentiary regulation in its entirety. The ALJ's decision and the review board's decision, a claimant or any party could submit unlimited pulmonary function tests by routing them through one expert. And the same logic would allow unlimited X-ray rereadings that are labeled as review. And it's the position of the petitioner that we don't believe that that's what this regulation contemplates.
It's certainly not. It certainly is what the regulation says. I don't know what it contemplates, but it doesn't say what you want it to say. I'm happy to hear more about this if you like, but if assume for a minute that this argument fails miserably, does that sort of resolve the case? Because then Dr. Go's evidence is in, and we're like reviewing it for substantial evidence, and we're basically done at that point?
No, it doesn't resolve the case, Your Honor, and I'm glad you asked that. Notwithstanding what we believe to be that evidentiary violation, legal pneumoconiosis was not proven. Dr. Go's opinion is unreasoned. He diagnosed legal pneumoconiosis based on pulmonary abnormality, lung function decline, and obstruction. But he testified that these findings are not a specific disease. They are not specific to coal dust exposure, and symptoms like wheezing are commonly associated with asthma. And the record was replete with evidence that the claimant has suffered from or has had asthma since 2009. Dr. Go dismissed the asthma by speculation. He said essentially that, well, many
Well,
people
and the
are-
ALJ reviewed all of the expert reports and agreed with Dr. Go. And we're here now on the standard is substantial deference. So how are we not? I think you're asking us to completely stand in the shoes of the ALJ and do their job, and that's not our job.
Well, to review the ALJ and the Benefits Review Board, we believe that the ALJ violated that substantial evidence standard as well. The evidence was overwhelming that the claimant had asthma, and that was not caused or aggravated by coal mine dust exposure. It was repeated diagnoses by his treating physician, Dr. Samara Tassi. He had episodic wheezing and cough, normal diffusion capacity, hospitalization for wheezing, and basically the ALJ short-sightedly focused on one 10 milliliter shortfall under one guideline, ignoring the totality of the clinical evidence.
Well, the ALJ didn't ignore all the evidence. The ALJ laid out its reasoning for why it entered the opinion it did. That included a discussion of the evidence that you're talking about.
But, well, it's our position that the ALJ's reasoning is flawed, that the substantial evidence was overwhelming, the claimant's lung function was stable through his coal mine employment. The pulmonary disability appeared after his cardiac bypass surgery, and as a result of chest wall changes as a result of that surgery. And the evidence was overwhelming that asthma explains the obstructions that he's having. And so the ALJ seized on those isolated phrases, ignoring these opinions of Dr. Zaldivar and Dr. Rosenberg, and even one of the concessions of Dr. Forehand, one of the claimant's doctors, and overlooked all of that. Even Dr. Forehand conceded that the response of the claimant in these tests met the ATS reversibility standards, the American Thoracic Society. And I see that I am out of time.
All right, thank you. You have some time in rebuttal, Mr. Kawash.
Okay, thank you, Your Honors.
All right, Mr. Petzold.
Thank you, Judge Thacker. I think Your Honors seem to understand the appropriate standard of review here, and this case really gives the court the opportunity to underscore the proper standard of review in these federal black lung cases, where this court should not be called upon to reweigh the evidence in every case. And that's really, as I think Your Honors understand here, that's essentially what this this appeal boils down to. First of all, as you've all, I believe, indicated, the evidentiary limitations do not limit treatment records. And if a minor has happened to have a lot of pulmonary function testing in their treatment records, that may come in because it's valid and probative as a treatment record. As you indicated, Judge Keenan, it was not developed for the purpose of litigation. These evidentiary limits, what they actually, it may be instructive to explain, under the rules under 20 CFR 718 section 204, there are 4 methods of proving totally disabling pulmonary impairment in the Black Lung Act. And one of those methods is by providing a detailed pulmonary function test report that shows graphs and charts of all the trials in the test, all the different efforts that the minor made. This is a complex piece of evidence that judges have to scrutinize. And that is not a typical treatment record. That's very different. That's something you look at in an academic setting or a litigation setting, this complex PFT report. That is what is one of the means of proof of disability under 718-204, and that's the type of evidence, the documentary evidence that's limited by the evidentiary rule 725-414. The rules don't want judges fishing through hundreds of pages of curves and charts on pulmonary function tests. That's not there are 4 ways of proving impairment under the Act. One is by PFTs through those charts. You can get 2 of each and a third one on a modification proceeding. You can prove disability by arterial blood gas or core pulmonale with echocardiography. And then most pertinent here, you can prove disability by under 718 section 204B4 B24 by a reasoned medical opinion, and that's what we have here.
And I think I understood Mr. Kawash's argument, at least in part, to be that the problem that he's having with Dr. Go's report is that Dr. Go conducted his own separate interpretation of the PFTs, and that's what made it in excess of the limit.
Your Honor, right. That's just simply not what the rules say. That doesn't in 718-204 204B24 describes what a reasoned medical opinion is. It's a finding by a physician exercising reasoned medical judgment based on medically acceptable clinical and laboratory diagnostic techniques that addresses the pulmonary impairment of the minor. And so Dr. Go's report is just that. And it's a permissible type. It's one of the means of proving impairment. It's a means of proving causation. You are not, in fact, the rules contemplate that those doctors who are reviewing experts, they do look at the treatment records. The Benefits Review Board.
It's basically what experts do, right? They review the record and they provide their assessment of the record in their report.
Exactly, and at JA 807, the Benefits Review Board said the same thing, and they said, they make a really important point, which gets to the second issue here. So let's say Dr. Go's report should be limited or reduced in weight. Well, the other company doctors also relied on these same pulmonary function test records. They all did the same thing. They all looked at these records. So even if the company were right here with this argument, it's a wash in terms of the relative probative value of all these reports, because all of the reviewing doctors looked at the same PFTs. And so if you're going to, this argument really doesn't move the needle, even if it had.
Help me understand. This is maybe curiosity instead of relevance, but why did this guy have so many PFTs? As you sort of described them, these are like pretty unusual. They're pretty detailed. I think you said they're typically sort of in the academic context or maybe a litigation context. Why do we have so many of them for this particular claimant?
Well, what's in academic contents is all of the lab reports from each test. Those are extensive reports that show spirometric curves and so forth. It's common for a person with COPD to have pulmonary function testing every couple of years, and that's what this minor had. And all of the lab reports from that testing are not in the record here. And so that part of the company's objection is that there is a limitation on pulmonary function test reports. But all of these test reports are not in the record, just the treatment notes about them are in the record, and those are reasonably part of treatment, and they should be considered by the physician. So it's common to have pulmonary function testing. What's uncommon is for a judge or a doctor to look at all the curves and the function and the effort over. That's what the ALJs wind up doing in these cases, is they look at a lot of the mechanics of the administration of the test to determine whether it's adequately reliable to assess disability. And that's what that kind of detailed report is limited. We don't want these records cluttered up with a lot of spirometric reports, and they're not, because those kinds of reports that can only have 2 of them under the evidentiary limitations. But a reviewing expert should certainly be able to look at the treatment notes summarizing the
Did
pulmonary
that
function.
answer your question, Judge Richardson?
Yeah, thank you.
Okay. So, Mr. Petzoff, do you want to address the substantial evidence argument?
Yes, well, as I indicated, well, you say the Judge Timlin, Teresa Timlin, saw this case a couple of times. This minor filed the claim in 2012. I came in as counsel shortly before it went to the first hearing, and Judge Timlin did not have all these treatment records and expert testimony at that time. So she conducted 2 exhaustive analyses of this case in 2019, and then again when we came back to her on modification in 22.
Yeah, I did have a question about the modification. What was the mistake of fact or change in condition that required a modification?
Well, this gets to the substantial evidence issue. She found that the minor did have black lung on the second hearing. And she credited our expert more heavily because
So it was a
found
mistake of fact?
a mistake of fact. She initially found the minor did not have black lung, and he was always totally disabled, but on the first hearing she found he did not have black lung. But when she looked at our additional treatment records, she saw that he had long-term COPD, he had symptoms consistent with pneumoconiosis. Then she found, based largely on Dr. Go's report, that he did have black lung, and she placed less weight on the company doctors thereafter, reasonably, because they mistakenly found the minor did not have black lung. So substantial evidence supports her opinion because she reasonably weighed the treatment records and the expert reports and found that doctors Forehand and Go accurately diagnosed black lung disease, and therefore she placed greater weight on their conclusions regarding the ultimate question of causation of total disability because she found they had accurately diagnosed the pulmonary condition. And so substantial evidence supports her ultimate conclusion there. Under the Toller and the Scott cases, this court has found the ALJ may reasonably place greater weight on the ultimate causation opinion of a expert if the ALJ finds the expert made an accurate diagnosis regarding the pulmonary condition. And here she found, Judge Timlin, she found that the minor did have black lung, so she placed reasonably greater weight on Go and Forehand, who made that diagnosis of black lung. I think, we can get into, there was great testimony at immense length about potential other contributors, but Judge Timlin looked at that. She found that there was equivocal evidence about asthma. She credited Dr. Go, who observed that although there were some stray references to possible asthma in 2012 and 2013, Dr. Go observed that the treating physicians had not diagnosed Mr. Mullins with asthma for 10 years, not since 2013. Instead, there were consistent diagnoses of COPD, which is a species of pulmonary impairment associated with occupational lung disease. And so Dr. Go's opinion, in part, was more consistent with the pulmonary treatment records, and maybe substantial evidence, is further supported by that consistency. And Judge Timlin credited all of that in weighing Dr. Go's opinion more heavily.
All right, thank you. Have you covered everything that you wanted to cover, Mr. Petzoff?
Your Honor, I would just stress that we stated the standard of review under the Hobet Mining against Epling case, the Fourth Circuit case dating back to 2015. Substantial evidence is a well-defined. The employer here is trying to opened the floodgates referencing the CB Mining against Addison case, which was a special case dealing with CT evidence where this court did probe the evidence, again, on appeal for substantial evidence, but that was a very limited situation dealing with an evidentiary limitation pertinent to CT images, and the standard of review here is deferential. It's substantial evidence. As long as a reasonable mind might accept the evidence as adequate, this court should generally affirm the holdings of an ALJ, and I would hope that the court underscores the proper standard of review here so that we don't have this sort of floodgate version of CB Mining that opens every black lung case to evidentiary reweighing on appeal before the Fourth Circuit. And that's all I would ask you. I thank you, Your Honors.
All right, thank you, Mr. Petzold. Mr. Goldberg, you have 5 minutes. You're muted, Mr. Goldberg.
Okay, thank God it not, thank you. May it please the court, my name is Jeff Goldberg. I'm representing the Director of Office Compensation Programs, and I will keep this very brief. The ALJ's decision to admit Dr. Go's reports is consistent with the evidentiary limitations at section 725.414. The plain language of those regulations controls. The parties agree that the treatment records are admissible. They agree that the pulmonary function tests reviewed by Drs. Go, Rosenberg, and Zoldivar were treatment records. Section 414A1 permits doctors to review admissible evidence for their medical reports. Subsection A2I permits doctors to review any admissible pulmonary function report. And the parties agree that these treatment pulmonary function reports are admissible. And section 414A22I permits doctors to review any admissible pulmonary function reports. Finally, subsection A4 permits the admission of treatment records, including the pulmonary function test, regardless of the evidentiary limitations. And that's what the Dr. Go did. He reviewed the treatment pulmonary function test. He referred to them in forming an opinion on the minor's condition. The ALJ acted in accordance with the regulations and admitted them. It's just that simple. Cedar Cole's argument would lead to less thorough reports for no good reason and require needless hair splitting from ALJs. I don't know how they would be expected to accomplish that or what the purpose would be. We ask that you affirm the ALJ's decision to admit the reports.
All right, thank you, Mr. Goldberg. Mr. Kawash, you have 2 minutes, I believe, in rebuttal.
Yes, thank you, Your Honors. Just very briefly, Mr. Petzold, my colleague Mr. Petzold said, the ALJ credited Dr. Go's opinion because the reason he did is because he had 9 reports, independent, own separate interpretations and results that were affirmative evidence. And once they're affirmative evidence, they're subject to the numerical limits. And so accepting the director's view creates a loophole that would swallow this rule. If a party can submit unlimited new interpretations of objective tests simply by labeling them as assessments inside a medical report, then the evidence limits are meaningless. So the limits only work if new interpretations count as new evidence. And finally, the error here was prejudicial. The ALJ indicated that the case came down to Dr. Go versus Dr. Ranavaya, and that Dr. Go was only slightly more persuasive. And the ALJ relied on Dr. Go's opinion after allowing him to exceed the limits and to violate this to ignore all of the other evidence that was present of asthma. If Dr. Go's report is excluded, then the outcome changes. And under Addison, that is reversible error. So this case is not about preventing doctors from giving opinions. It's about enforcing the rules that Congress and the department wrote to ensure fairness and limits in black lung litigation. And for those reasons, we pray that the court would reverse or at a minimum remand for reconsideration under a proper evidentiary framework. Thank you, Your
All
Honor.
right, all right, thank you, Mr. Kawash, and we want to thank all the attorneys. Were we in Richmond, we would come down and greet you, but merely because we're remote does not mean we appreciate your arguments any less. So thank you for your advocacy this morning, and the court will take a brief recess and reconstitute the panel.
Okay. Thank you.
Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Good morning. Ms. Santillo?
Yes.
Ms. Ray?
Yes.
Good morning.
Can you hear me?
I can hear you. Yes, I can
I'm
hear
only
you.
on the audio this morning, but I want to welcome you to the Fourth Circuit. It's good to have you with us.
Thanks
And,
very much. Thank you.
With Judge Thacker and Judge Richardson. And we have the case of the United States versus Joyner, Colby Joyner, number 244565. And Ms. Santillo, you represent Mr. Joyner.
That's correct, Your
The
Honor.
floor is yours.
May it please the court. My name is Kristen Santillo on behalf of defendant appellant Colby Joyner. And we raised a number of issues in our briefing, multiple evidentiary, instructional, and sentencing errors. But unless the court has other questions, I want to focus on two sets of errors today. And the first is
You say 2 sets of errors? What do you call it?
that's correct, two sets of errors, because I believe that they complement and reinforce each other. So the first set of errors is the trial court's erroneous exclusion of all evidence relating to the overarching alleged charged healthcare fraud scheme on the grounds that it didn't bear on Colby Joyner's own conduct and intent, while at the same time, at the close of evidence, instructing the jury that they could find Mr. Joyner guilty under an aiding and abetting theory. I think that this was a fundamental due process violation because critical evidence was excluded, which would have allowed Mr. Joyner to meet the elements of the case if he had been able to. But, you know, after the close of evidence, the jury was presented with a theory that he was unable to meet. And, you know, we've cited authorities that were acknowledged to be valid by the Fourth Circuit. In the Second Circuit, that's recognized that that's a due process violation when the defendant is simply unable to meet the evidence on the theory that went to the jury. I think it's clear that the district court...
Well, it's more than that he was unable to meet it. He did not have an opportunity to meet it because his evidence was excluded.
Exactly. And, you know, it's just a fundamental due process violation. I think that's well established. There's irreconcilable... I'm sorry.
Are you raising a constitutional question or an evidence ruling question?
Well, yeah, I think
You're
that...
talking about process now.
Well, what I would say is that I think there was a fundamental error in...
I thought you were asking Judge Conrad's ruling to exclude the evidence. And now
Well-
you're going to the Constitution.
Well, what I think that...
One of them is reviewed for abuse of discretion. That's the one you've preserved here.
Yes, no, that's absolutely right. We're making the evidentiary argument because I think it's fundamentally legally incorrect. And I think when a trial court makes an error that's rooted in a misunderstanding of the law or a misapplication of a clear legal principle, then that is an abuse of discretion. In this case, the court said, well, Mr. Joyner's not charged in a conspiracy, so really the only relevant evidence is based on his own conduct and intent. But there's well-settled law that a scheme is very similar to a conspiracy, and evidence about the overarching scheme is relevant to bear on whether there was even an existence of a healthcare fraud scheme. That's an element of the offense. And so the court...
He was charged as a principal and as an aider and abettor, correct? In 7 counts.
Correct.
And those aiders and abettors were identified.
Those aiders and abettors were not expressly identified. Well, they were identified in the indictment. Yeah, that's correct. Yes.
And no one ever asked for a bill of particulars. Was there a
No.
motion for bill of particulars?
No. I think there was an understanding that there was an alleged fraud scheme that involved Mr. Joyner was a part-time employee for MCS.
So he's the only aider and abettor that's charged. He's the aider and abettor. And he's charged under Section 2 as an aider and abettor. And
That's
an
correct.
aider and abettor principal under Section 2.
That's
Doesn't
correct.
make any difference.
It doesn't make any difference except the fact that the government has a burden to prove that if they're going to establish aiding and abetting liability, that somebody else committed the underlying fraud. And so Mr. Joyner has an interest in
That's not
defending.
what the allegation is. The allegation is that he was he aided and abetted, and he's charged under Section 2. And an aider and abettor under Section 2 is a principal. Anyone that aids, abets, counsels, assists, etc., is a principal under federal law, under the U.S. Code, Title 18, Section 2.
That's correct, but the elements.
And Judge Conrad read Section 2 to the jury in the instruction.
Yes. But my point is that an element of aiding and abetting liability is that there has to be another person who has committed a fraud.
And Ms. Centello, isn't there a disconnect here between the reason the district court gave for excluding appellant's evidence, which was that the appellant was charged as an individual, and then the follow-on aiding and abetting instruction?
Absolutely. The court's decision was.
The court keeps, go ahead.
Oh, I'm sorry. Go ahead.
No, you go ahead.
The court's decision basically said that, the indictment focused on the conduct and intent of Joyner, and MCS is not on trial, but when imposing the.
Can I ask this question? I will confess, like Judge King, I didn't exactly understand this to be your argument, and so I'm just trying to make sure I understand it. Did you object to the aiding and abetting instruction?
Yes. There was an objection.
And where in the brief is that a preserved issue? Like, where am I? I'm just like, I get the evidentiary issue, and I get the argument that there should not have been an aiding and abetting instruction. I just haven't put them together, I guess is what I'm just trying to understand why you've grouped them together. Just help me understand that a little bit.
So I grouped them together because I think that if there was going to be an aiding and abetting theory presented to the jury, it was certainly relevant whether or not there were any other people who were in the scheme who were committing fraud or, on the contrary, acting in good faith. And there was critical evidence excluded that people who worked at MCS with Mr. Joyner were acting in good faith. And they had good reason to believe that the protocols that were in place that Mr. Joyner followed were compliant with the law, and that he was not aiding and abetting them.
So I sort of understood.
After instructions were completed by Judge Conrad, he asked for the counsel to advise him whether they had any objections, and they both said no.
No, well, there was an express, yeah.
Under Rule 32 of the criminal rules, nothing was done at that point. So how is that issue even preserved? I'm following up Judge Richardson's question.
So
It was discussed earlier in the trial, or even before the trial, but when the jury was instructed, there was no objection made. After the jury was instructed, before they went to deliberate, no objection was interposed whatsoever.
Well, so during the charge conference, trial counsel objected to the aiding and abetting instruction. And this is on JA 539.
I'm talking about the Rule 32.
And what I'm saying, and after the close of the case, they renewed all of their motions. They renewed all of their prior motions.
They renewed all of their prior motions or objections?
Objections and all their, they removed, as I understand it, and I have to go back and check the record, that they renewed all of their prior
Well,
objections.
that's what we want to see in the record. So at JA 539, you're saying that's where they objected to the aiding and abetting instruction, correct?
Yes.
And then what was the other objection you were directing us to?
Well, obviously,
That's well before the instruction. I'm talking about after the instructions, for the deliberations, no objection was interposed.
I would have to go back to the record and clarify that. But I think, our argument stands that the jury was instructed on aiding and abetting, and the evidentiary ruling is wrong. It's a matter of law, and it prevented Mr. Joyner from being able to meet the theory of the case.
Charged in 7 counts with aiding and abetting, section 2. And the judge read the jury the provisions of section 2 of Title 18, which is the charge against the defendant. He's the only one that was charged with being an aider and abetter. They didn't name anybody else. They referred to others, and you never did ask who the others were.
Well, there are specific people who were named in the indictment, including Christopher White, MCS, other providers at the company where he worked. What the problem is with the government is that Mr. Joyner...
Reviewed in the light most favorable to the prosecution, the jury may have found them all to be aiders and abettors, but the only one that was charged as an aider and abettor was this defendant.
Yes, and if there had actually been a trial to determine whether or not, or a fair trial, or Mr. Joyner was allowed to present evidence about how the overarching scheme worked, it may be fine if there's an aiding and abetting instruction. The problem is at the beginning of the case, the government said, we're only focused on Mr. Joyner's conduct alone. He's the only person who's involved in this scheme. And the court agreed with them and said,
So
any evidence relating to evidence.
The indictment says he is an aider and abettor with others known and unknown.
Yeah, but it also lists specific people, who are identified in the indictment. I think Mr. Joyner tried to. I'm sorry, I didn't hear that last part.
Because you didn't ask who the known and unknown were. You can make a motion for a bill of particulars in a criminal case in the federal court. You didn't do that.
I don't think there was a mystery about who was involved here. I think that Mr. Joyner was a part-time employee for the company that was MCS. There was one person who was a client.
I think the issue about the aiding and abetting is frivolous, to be honest with you. It's a waste of time. Now, your question on the evidence, maybe it's separate, should be, but you're trying to tie the two together.
Well, I think that, I don't think they necessarily have to be tied together, but I think they are, the fact that the court erroneously excluded critical evidence on an erroneous legal theory.
Can I
when the healthcare fraud is.
Can I ask a question, counsel? I just want to make sure. So, just for a minute, hypothetically, assume that I'm only asking about the evidentiary question, right?
Yes.
As in isolation. I'm just trying to simplify. Help me understand why it would be an abuse of discretion to exclude that evidence under Rule 403. And in particular, and I'm sure that Judge King will give you time to answer this, but in particular, the value of a legal opinion or emails or, somebody's report that a business is operating legally is only useful if you know the precise information that they were provided. And so I can go to a lawyer and I can describe what I'm doing. And if I do that dishonestly, I can get a letter from the lawyer that says what I'm doing is like wholly legal. But that may well be because I have misrepresented or failed to provide all of the details. Or I can provide all the details and still get the letter. But the point is, we almost never allow these sorts of mini trials into a question of legality of conduct. Because if the lawyer was right or the lawyer was wrong, absent a reliance on counsel defense, that opinion letter can't change whether the scheme is legal or not. And so we would have, if the court were to have permitted the introduction, just to take the legal opinion as one example, although I think they're all in the same bucket, if the court had let that in, presumably then there would have had to been multiple witnesses who then tried to describe what information was included or excluded when the lawyer was asked for that opinion, to try to understand whether the lawyer's opinion, even though it can't provide legal guidance to the jury, that's what the judge's job is, whether it was reasonable or something that could have been relied upon. But we know it wasn't relied upon. And so I understand your relevance argument to the extent that you've made that. What I'm having trouble with is understanding why under 403, this isn't like paradigmatically the kind of evidence that we say it's not sufficiently probative to allow us to get into this sort of whole sideshow about what information was provided and how it was provided, given that he never saw any of it. Can you just walk me through that a little bit?
Absolutely. So I agree that the legal opinion is probably one of the more complicated pieces of evidence that was excluded, but there's much more straightforward evidence that was excluded.
Well, why don't we start with the legal opinion, and then if you want to explain why the legal opinion, maybe you think the legal opinion was properly excluded, why it's different for the others, because to me, the others are like basically the same problem as the legal opinion. So you can respond any way you like, I guess. But I started with the legal opinion, but if you want to skip that one and go to something else, that's fine too.
Well, I would say that I'll give you an example. The government argued to the jury that Mr. Joyner was, must have known that this was illegal, and that he was keeping the fact that he wasn't a practicing nurse from his employers, and any licensed medical professional would have known that the statements that were in these forms were false. The excluded evidence shows that the medical director who at MCS was sent all of the forms that Mr. Joyner signed. These are pre-populated forms that were created by somebody else before Mr. Joyner joined the company. Were sent all of these forms in June 2018, and he began reviewing, he was asked to review the process for compliance issues. So he started reviewing those forms for months before there was a training video that was shown to Mr. Joyner, which the government claimed was an obvious fraud. And he says on the video that he, dotted his I's and crossed his T's when he was reviewing this compliance. When he was reviewing.
But all of that presumes, just like, that just presumes that, like, he's not a criminal.
Yes.
Right? So we would have to have a whole discussion about what information he had and what was done. And so where he's relied on it is one thing, but like whether what he was doing was legitimate or whether he had the right information would be a whole separate trial about whether this person was doing that. And so absence of reliance, I'm still having trouble. That seems to me like no different than the legal opinion. Right?
Well,
you want to say there's a medical opinion. I don't think there actually is a medical opinion, but you call it a medical opinion. But it's this sideshow that 403 sort of specifically seems to be designed to like not require a trial judge to let take place. I mean, that's the discretion the trial judge gets.
But the issue is that Mr. Joyner was being, held potentially accountable for the criminal conduct of his boss. And this is an email that shows that the good faith of his boss. The appellate.
No, the email doesn't actually show his good faith.
It
right?
doesn't.
The email doesn't show his good faith. It
goes to his boss's good faith, and he's being held accountable for aiding and abetting his boss. That's what I'm saying, is that he's not able to.
So that your argument is on its face that establishes the boss's good faith. And if I disagree with that, then you agree that the district court judge acted appropriately within his discretion.
Well, I think there's a number of things that show that the people who were working at MCS were, consulting people, they were trying to be compliant, they were researching issues, including the central issue in the case, like what does the term patient mean? There was actually an email where they were given a definition of the term patient that it said that that term can extend to asynchronous encounters. They were comforted, and it was right around the same time that Mr. Joyner was trained on this protocol, that that term is consistent with the forms.
All
So-
right, thank you, I appreciate it. Sorry, Judge King, I know I ran you over, but I appreciate the opportunity to hear from counsel on that issue.
Yeah, that's no problem, Judge Richardson, and I want to mention one more thing. As long as you get questions, you need to go ahead and answer them. And I'm going to get to Judge Thacker. She is going to have some questions, I'm sure, before we go to the government. But I got to make a correction and an apology to you. I cite Rule 32 about objections to instructions, and the correct rule is Rule 30D. I'm sorry, of the criminal rule is about objections, and you have to make them at the right time after they're given, a specific objection before the deliberation. And here, neither side made any objections after they were given. And as to the aiding and abetting, the court did nothing but read the statute, which is cited in each count, the 7 counts, the aiding and abetting statute, word for word.
Yeah, and I don't think that
Word for word.
I don't think there's an argument that aiding and abetting instruction was wrong if it was appropriate to be given. I don't think that there was an argument that it was misread, or that was a misstatement of the law on aiding and abetting. It just never should have gone to the jury, and there was an objection about that issue.
Well, and isn't your point also that giving that instruction highlights the error in excluding appellant's evidence in the first place?
Exactly.
So I also just want to say, I, for one, don't think that your argument is frivolous on that point, Ms. Santillo.
Thank you. I realize I'm out of time. If anybody has any other questions.
As long as you get questions, you answer them.
Okay. Thank
Your
you.
chance.
So, I'm sorry. I'll pass it over.
So Judge King, you can't see, but I think Ms. Santillo is finished with her argument.
I can't see. I don't know what. Has she been muted?
No, I think
No.
Ms. Ray is ready to go whenever you're ready for her to go.
Oh, I'm ready, but are you finished with the counsel for the appellant?
Yes.
Judge Sack? I
Yes.
didn't want to cut you off on counsel for the
Yes.
appellant.
Yes.
You're finished. Our business, the government. Good to have you with us, Ms. Ray.
Thank you, Your Honor. May it please the court, Amy Ray for the United States. Your Honors, Mr. Joyner got a fair trial and his sentence is procedurally reasonable. I will turn first to the question of the evidence, and I want to make a few notes. First of all, this isn't a constitutional claim. United States versus Malloy, 2009, it's in our brief, is, he was allowed to present evidence that everybody else acted in good faith and they all thought they were in compliance. And so it wasn't as though he wasn't allowed to argue his primary defense. And what Malloy says...
That evidence was his own testimony, right?
No, Your Honor. It was also, for example, emails on page 397 to 398. There are emails that say that he received in which it says, our practice is conducting a professional and compliant operation. The practice is guided by a veteran medical director who has over 30 years of experience. The medical professionals
But nobody could talk about the medical director, right?
Well, I mean, Mr. Joyner.
Which one was the medical director?
Mr.
Was that-
Smith.
Okay.
Yeah, Mr. Smith. And I think, Judge Thacker, if I believe that if the court looks at the entire record, it's very clear that he was allowed to present this defense. And so in terms of the standard of review, the crux of the argument is evidentiary. It is not constitutional. And so it is an abuse of discretion
I agree with
standard.
that.
Thank you. And so that means Judge Conrad had to be arbitrary or capricious in responding, in excluding the evidence that.
Can we, I guess, I'm sorry, Ms. Ray, but can we back up and could you just explain to me what the scheme here is supposed to be? Because I can't quite grasp what the scheme was supposed to be here and what was in it for Mr. Joyner.
Oh, okay, sure, Judge Thacker. The scheme was a telemarketing scheme where there would be client companies, and one of those companies was run by Mr. Smith. And the client companies had people who would cold call elderly folks. And they would call these folks, and in fact, there's evidence in the record that they would call 5 times, and if they didn't receive an answer in 5 times, that was good enough. They could let it go. But in any event, they would call these older folks, and they would say, hey, you know.
I guess what's the scheme on the part of, what is the scheme on the part of Mr. Joyner individually? Because that's why his evidence was excluded, at least that's what the district court said.
Well, that was part of why the evidence was excluded. I do want to answer your question, but I also want to make the point that it was also excluded under Rule 403. And although Mr. Joyner cites Rule 403 in his opening brief, he makes absolutely no argument with respect to.
Well, the district court also didn't really make a Rule 403. Where did the district court do a proper Rule 403 balancing test?
The district court, in its written order, explained that it was misleading and it would lead to confusion.
In its written order, after?
Yes,
oh,
yes.
Okay.
Yes, and also he did talk about Rule 403 in the oral order as well when he did it.
But where's where's the balancing test in the written order?
It's I mean, first of all, I do want to return just to one point, Judge Thacker, if I may, and I do want to answer your question, but I also want to say that an argument that a passing shot is made, right? No argument is developed in the opening brief about Rule 403. It is our position, and I think it's a strong position, that the defendant has waived any challenge to the Rule 403 decision.
No, I understand that, that argument. They may, I mean, the court's analysis even, the two are intertwined, 401 and 403, at least in terms of how the court handled it. But I understand that you're saying the appellant waived it.
Absolutely, and I think that there was no, in other words, the appellant never said anything about a balancing test in her opening brief, or his opening brief. But in terms of the...
Do you think, just before I know we're distracting you, but in a trial, do you think there is a requirement that a trial judge from the bench ruling on 403, that it orally articulate the reasons for the 403 decision?
I do not. And not only that, but I think there is no requirement that in a later written order, the judge go into any detail about the depth of the balancing test. The Rule 403 requires that the judge conduct one. So if this court were to look at it and say, oh, there's no way a reasonable trial judge could conclude that this would lead to possible confusion of the jurors, then that's fine. But there was no requirement for Judge Conrad to go into any detail. Now, I do want to address, Judge Thacker, your suggestion that these were intertwined. They were intertwined insofar as 401 is a relevance objection, and part of Judge Conrad's issue with 403 was that it would lead to, that it was unnecessary. But also, he said it would lead to confusion of the jurors. And there was a good reason for that, because Mr. Joyner had never seen any of these emails that were excluded. And those emails simply said, we think we're compliant, but they gave no context as to why they thought they were compliant or what exactly, they would respond and say, we're trying to be compliant.
And that's the 403. How are they not relevant to this scheme as you've described it? Because you when you started describing the scheme for me, you talked about the company and that it's
Yes.
run by Mr. Smith and all that. How are documents about the company and how they ran this operation not of any relevance?
So, I may have misunderstood your question earlier. When you asked about the scheme, I thought you were asking me about the broad scheme and not just about Mr. Joyner. I can answer that more
Now, I
specifically.
am just asking about Mr. Joyner because I just don't understand what the scheme is with respect to him. Does the
Yeah.
government agree that Mr. Joyner got paid the same regardless of whether he ordered these tests or not?
Yes, but he ordered
Did
the
you say
tests.
yes or, I'm
Yes,
sorry.
but he ordered the tests. He ordered multiple tests for everyone, whether or not, and even when the supposed medical screening that happened reflected no need for the pharmaceutical test or for cancer test, he ordered the tests. For the reason he didn't interact with them. He signed orders for about 600 beneficiaries, but over 14,000 tests were run based on the orders that he entered, because he went through and just checked every single one of them. The reason, his part in the scheme, Judge Thacker, is this: he did not attest to he said that they were medically necessary, and he went through and just signed his name. He didn't review it. He did all of these in under 5 minutes. And so he said they were medically necessary. They were not. He said that these folks were his patients. They were not. He said he was going to follow up and provide care based on these tests. He had no intention of doing that. So his role in the scheme was, first, he had the Medicare enrollment that they needed. He was a licensed Medicare provider. He did not comply with the Medicare rules, but he also flat out lied every time he signed that something was medically necessary when he did not do any assessment as to medical necessity. So that was his role. Now, in terms of whether or not everybody else thought that it was compliant, and let's say an email between Ms. Polhill and Ms. Smola, where
And he did all that for what?
for money. He made it.
But I thought you said he made the same, I thought you agreed with me that he made the same amount regardless of whether he ordered the tests or not.
Yeah, the problem is he pretty much always ordered the tests. So I don't think that
But-
fact is very helpful to him.
But that didn't change how much money he made. You said he did it for money.
He did it for money because they would send him patients, and he could, in 5 minutes, he could earn money because all he.
But he earned the same whether he ordered the tests or not.
Right, but he did order the tests. He ordered tests that cost.
And in fact, I don't understand this, when defense counsel tried to ask the investigator at trial if there was any evidence that any of the money went to appellant, the court sustained the government's objection. The government didn't want that question answered because of all the stuff that was excluded, because of the earlier rulings. For some
Your Honor,
reason.
I don't follow, Your Honor, on that, Judge Thacker. I think that the reason the government didn't want that into evidence was it was irrelevant as to whether or not he told lies. And he was charged with conspiring to commit healthcare fraud, but
Did any of the money
that.
go to appellant? Did any
Pardon
of the
me?
money go to appellant?
The money that went to appellant was the money that he was paid for signing and ordering tests.
Was his
that were not-
basic salary from the company, right?
Well, yeah, except it wasn't a salary. It was a payoff for ordering medically unnecessary tests.
But we already agreed that he got paid regardless of whether he ordered the test or not. He got paid the same.
There was an understanding, Judge Thacker, that he would order tests, and he ordered so many tests that the government paid over
I
$3.7
guess my problem is I just can't understand what the scheme to defraud is individually on behalf of Mr. Joyner. And I did understand the court to be excluding all the evidence that it excluded because it said this was about him individually and all the rest of this doesn't matter.
No, with all due respect, Judge Thacker, that is not an accurate assessment, and I'll tell you why. And I appreciate, I'm not suggesting that, anyway, here's the deal.
Just tell me where to look.
The government, I'm going to answer your question by saying the government never said that Mr. Joyner was committing fraud by himself. That was not what the government's position was. The government's position was he was a cog in a larger wheel.
No, yeah, I know that, and that's where my disconnect is, because the government does say he was a cog, and I understand that whole cog in the bigger conspiracy thing. I just don't understand excluding all of his evidence of the bigger conspiracy.
They didn't exclude all of his evidence. He got to testify. He testified. And
Well,
also, the evidence that they excluded,
Well,
Judge
the
Thacker,
government-
was evidence he never saw. How could evidence about emails he never saw be relevant to whether or not he had an intent to defraud?
It's evidence of the company's conspiracy.
Sure, but we didn't need to prove, we proved, and by the way, if you just look at the training video, I think it becomes pretty apparent that he is part of a cog in a quite illegal wheel, right? And so the jury heard evidence that this was a broader scheme, which makes sense. They should, because he's charged with participating in a scheme to defraud.
Yeah, and I understand all that. It's just what doesn't make sense to me is excluding the evidence that would have given him the opportunity to fully present his case, including, we haven't talked about the subpoenas for the witnesses. I mean, 2 of them, the subpoenas were quashed without them even being there. There's nothing on the record, there's nothing set out on the record that they, what the questions would be or whether they would refuse to answer them. No individual assessment. Could you talk about that just while you're here, since you won't get another chance?
Yeah, I'm happy to, and I appreciate the question. So first of all, it's an abuse of discretion standard of review, and I think that's important. The reality was, and first of all, I guess I'll go back, Fifth Amendment, right? As the relevant touchstone is whether any adverse consequences can be visited upon the person who's being asked to testify. That's 2025, this court's decision in Oliver. What Judge Conrad did, and in their motion for subpoenas and their memorandum in support, they accused every single one of these folks with wrongdoing. They accused not only White and Smith, but also Medcare. Now,
Right, but then they altered that theory before this decision was made on the subpoenas, right?
Yeah, well, they said they did, and yet they had repeatedly from the beginning of the trial, they had said that this wasn't his fault, everybody else was at fault. Mr. White was at fault, Dr. Smith was at fault. That was the working theory. Now, Judge Conrad has to protect those individuals' Fifth Amendment right and privilege not to incriminate themselves. And what he determined...
But there should also be a record of some particularized inquiry, and 2 of the witnesses never even appeared in court, did they?
Well, that's, yeah, because
That's
Why?
a lot of
right. I mean, they weren't there, but they had written a letter. They had said they were going to assert the Fifth Amendment right as to anything that was asked. And what Judge Conrad did, the particularized inquiry, and I'll quote from the Supreme Court's decision in Hoffman. The district court must be governed as much by his personal perception of the peculiarities of the case as by the facts in evidence. What Judge Conrad, after watching this evidence for, a couple of days, understood about the theory of the case, he knew that if those folks got up on the stand, there was every likelihood that they were going to be asked about their participation in what the government understood and what Mr. Joyner understood was an illegal scheme. And so they said, I think these questions will tend to incriminate me, my answers to those questions. Very reasonable, I think, for Judge Conrad to
And
say.
so no particularized inquiry was necessary based on that?
Judge Thacker, I apologize, with all due respect, I think there was a particularized inquiry.
How could there have been when at least 2 of the witnesses didn't even come to court?
The inquiry doesn't require an in-person evidentiary hearing. The inquiry requires that he consider their personal circumstances, the theory of the case by the defendant, what questions might be asked. That's the inquiry. It does not require, I have not read one decision that requires that the judge receive in person and have an in-person colloquy. And the reason he didn't in this case was because they were in California, because defense attorney misled them about when they needed to be back. And
well, I mean, you're in North Carolina and I'm in West Virginia. And here we are talking. So it's possible.
Well, it's possible if they cooperate, the witnesses. But more importantly, he heard from them.
Or if they have the information from defense counsel that they need to make arrangements to be there.
No, well,
Yes.
there's that.
And also, he heard from them through their counsel. Miss Colhill and Dr. Smith were, the counsel made very clear in the motion to quash why they were going to assert the fifth. And I just don't think that that it's an abuse of discretion for Judge Conrad, who has, of course, watched a lot of trials and heard a lot of trials and presided over them. He knew what the theory of this case was, and he determined that any question they were
I still
asked.
don't really understand the theory of this case, because I don't understand what the government thought was in it for Mr. Joyner. I mean, he was getting paid regardless. That's what I can't understand.
Is the implication, counsel, that if Mr. Joyner had stopped ordering 17 tests at a time, that the company at some point would have stopped sending him clients to review?
Yes, thank you, Judge Richardson.
Was this is his like sort of part-time job, right?
Oh, yeah.
Making
He said
like
he was making
$17,000 a year.
He said he was making $40,000 a year at this job. And he also said he was going to be able to make $60,000.
But we don't know how much Mr. White or the others made off of this scheme, because the government objected to any questions about whether the investigator traced the money.
That's because the money that the government cared about was the government's money. This is a healthcare fraud scheme. The entity that paid the most money was Medicare. It was $3 point something million. And
but then why wouldn't the government have traced, what's wrong with the question as to whether the government had traced the money that went to the laboratories?
Because
you're saying because the money that matters is the government's money, not the laboratories.
There were two pots of money, I think, that matter.
I understand what you just said, because it's the government's money that you care about and not...
it's a healthcare fraud scheme. It's Medicare fraud.
And not the people that were part of the scheme.
Well, right, not the people who weren't Mr. Joyner. I mean, we did explore how much he made. And he...
well, no, because when defense counsel asked if there was any evidence that any of the money went to appellant, the court again sustained the government's objection.
They still...
So you hear about it when it's the government's case, but then, well, not you. But
yeah, it's fine.
But exclude everything that he tried to do.
With all due respect, Your Honor, Judge Conrad did not exclude everything he tried to do.
Yeah, and I guess, and Ms. Ray, in your last time, I don't think you've been able to fully answer what is it that he was permitted to do, to put in evidence.
He was permitted to, first of all, he cross-examined our witnesses, and he regularly asked about whether or not he would have known and what input he had. Was he aware of the fraud, etc.? And then he put in the training video, which says we're compliant, and he testified, and there were emails that the government put in where he was told that they were compliant and professional. He made it very clear in his, I see that my time is up. Judge King, may I continue answering the question? Okay, yeah, I'm getting a nod. Thank you.
As long as you have questions, you're going to have to answer them, Ms. Ray.
All righty. I'm happy to. I love this. Anyway, your question about totally lost.
You were giving me a listing of all the things he was allowed to do. He put the video in. He testified. He cross-examined witnesses.
Yeah, there were emails. I mean, I think it
Oh, the
would be
emails,
hard
yeah.
to read this transcript. His opening statement identified kind of who was responsible. It wasn't him and why it wasn't. And then the closing, and then he was relying on all of this evidence that he didn't know. And there was a lot of it, including the emails that I quoted from earlier, where he was emailed and it said, hey, we're compliant, we're professional. There's a lot of evidence in this record.
And the line, can you just explain a little bit that line? So you said he was allowed to put in all the evidence and records that he saw or had knowledge of.
Right.
And so that's this last bucket that you've described. That he was allowed to put in anything that he saw or had knowledge of or that was part of his calculus. What he was not allowed to put in were just those things of which he had no knowledge.
Exactly. That's right. Exactly. If he did not know that there was an email between Ms. Polhill and Ms. Smola saying, oh, well, we better make sure we're compliant, that doesn't have any relevance to his intent to defraud.
And then the second point you'd made is to determine whether it goes to good faith or not, we would actually have to explore the purpose and the inputs behind that email. Because it could be a CYA or it could be an honest good faith effort, just like a lawyer's letter can be a CYA based on incomplete information, or it could be an honest good faith effort. And those sort of side trials, particularly in light of some of the privilege issues, were why the 403 issue was appropriate.
Absolutely, and I will note that the legal memorandum, for example, Judge Richardson didn't opine at all about the scheme other than whether or not it violated anti-kickback laws, and that, even that, you know, as Your Honor pointed out earlier, we don't know what was said, and the defendant hasn't even identified the policies that they think should have been admitted, but most importantly, the jury had to determine what was in Mr. Joyner's mind. And if he didn't read it, the judge could make, I think it wasn't arbitrary or capricious for him to decide that all of those side issues weren't relevant and would cause a waste of time, confusion, etc. Your Honors, I hesitate to close without addressing the aiding and abetting issue, but I'm also happy not to do that if Your Honors don't have questions about it.
Give us the short version.
The short version is there's nothing inconsistent with his being possibly liable as an aider or abettor to a larger scheme that the jury heard evidence of, and limiting what evidence the jury heard to evidence that it went to his particular intent to defraud. So I don't think there's any inconsistency there. I do want to make one note in the reply brief, and this just is important to me. Mr. Joyner suggested that that the government had conceded that the false statement instruction was wrong. We did not concede that. I jumped to plain error because it was, I thought it was pretty strong argument. I don't think actually, as I looked at it further, that it was erroneous under Thompson, but I just want to make sure that we're clear. I didn't make the argument that it wasn't, so that's fair, but I did not either concede it. So I just want to make clear about that.
Ray, don't sound that.
Yes, sir.
They three issues, I think there are two or three about sentencing. And
yes.
We didn't give counsel, Ms. Santillo, an opportunity to mention those, but I want you to address the sentencing issues.
Happy to, Judge King. So there were three sentencing issues. The first one was intended loss, and the district court went right with the guideline, which is you should use intended loss, and in a healthcare scheme where the government's money is at stake, you use the amount that was billed to the government, and that's the presumption, that's the prima facie case. And there wasn't.
Oh, you're frozen. Ms. Ray is frozen.
I mean, I think your video.
Miss Ray, if you're able to get out and come back in with the meeting
Can we get her
link,
back?
I'll contact her by phone.
Okay. So stand easy. And Judge Richardson frozen too.
I don't,
No, he's not frozen.
He's not?
Okay.
Okay. What's the
I think I'm
big
okay.
hearing? Okay.
it seems like I'm frozen when I'm not talking, because I'm mostly talking.
She can always leave and come right back in, okay?
Oh, there we are. Sorry, for a second, my screen said we were disconnected. The guideline doesn't say anything about victims with respect to mass marketing. It does say it in other parts.
Can I go back, sorry, Ms. Ray, to the first one?
Yes.
On the intended loss point, I understand the sort of presumption that we use the intended loss amount. But we do that only when it's like reasonably foreseeable to the person. And I guess, help me understand why it was reasonably foreseeable here of 10 million?
Yeah. I'm sorry, I just had an interruption because I think that somebody called us to tell us the meeting was disconnected. Your Honor, your question was why was that reasonably foreseeable to him?
Right, what evidence supported the notion? I mean, I will just say, I'm not a doctor or a PA, but when I saw 17,000 tests, my first move was not to $10 million worth of tests, right? And so,
Right.
what evidence was it that it was reasonably foreseeable to him that these tests were as expensive as apparently they are, such that that $10 million number would have been reasonably foreseeable to him?
Yeah, I don't think there was evidence specific to him about how much the test, I don't recall evidence about how much the test cost that he would have known. But what he did know was that he was part of a massive scheme. So let's assume, even in restricting it to the amount of money that the tests that were, the money that was billed to the government because of his particular tests, we could have gone much broader under relevant conduct, right, to everything that was reasonably foreseeable to him. And if you look at the number of folks who were on the call and the nationwide sort of scope that this operation was trying to achieve, I don't think a $10 million billing is unforeseeable to him. But I don't know of any particular evidence that said this is what he needs. I think what the judge was doing was, Judge Conrad was simply looking at the commentary to the guideline, which says use the billing amount. And so he did that, and then he varied downward and for the amount that the government actually had suggested, which was the amount of money that was actually billed to the government as a result of Mr. Joyner's fraudulent activity. Does that answer your question enough, Judge Richardson?
It does, thank you.
Maybe unsatisfying, but that's the best I have, I think. So the...
Well, it seems like a lot, but what about the mass marketing issue?
Yes, sir. So the mass marketing, Judge King, there's nothing in the guideline that restricts the mass marketing increase based on the number of victims under, say, the Mandatory Victim Restitution Act or whatever. There's not anything that limits how we would define how many people were involved with the mass marketing. That's not in the guideline text, nor is it in the guideline commentary. And what the 11th Circuit, the 5th Circuit, and the 2nd Circuit have all recognized is, look, these folks whose health information was taken, who were the targets of telemarketing, and in this case, there's a really strong argument that they suffered some harm because the evidence was that if they got these tests, they probably were not going to get them covered again in their lifetime. So if there was a genetic screening done for this person, they probably wouldn't be able to ever have it again. And I happen to know that, we all know that the genetic markers change. Scientists discover all the time new genes that are related to particular illnesses. So they did suffer harm. And the 2nd Circuit recognized, even in the decision in Lacey, which Mr. Joyner relies on, that if there was evidence that the folks who were required for the fraud to occur suffered maybe any harm at all, then it would be an appropriate increase. But the 11th Circuit and the 5th Circuit both say, hey, victim isn't in the part of the guideline that talks about mass marketing. It doesn't matter how many victims were. The question is, did he employ mass marketing. And here we had lots of evidence that it was telemarketing. In fact, even Mr. Joyner himself said, I feel like a telemarketer. Does that answer your question, Judge King?
It does.
Okay, thank you.
But,
And then
go ahead, I'm sorry.
I'm sorry, I was just going to address the last sentencing issue, which is the abuse of trust or special skill, and Judge Conrad relied on his status as the Medicare enrolled provider and also on his skills as a physician assistant and highly educated. And I think that's well supported by the guideline. And actually, the defendant doesn't even contest the special skill increase in his opening brief. And so I think he's waived that issue in any event. Your Honors, I'm happy to answer any other questions. Okay.
Thank you very much.
Thank you. We request that the court affirm. Thank you.
Ms. Santilla?
Yes, so just following up on some of Judge Thacker's questions, I do think that the court's relevance ruling was used by the prosecution repeatedly to police questioning in the case and to restrict, any of the evidence that Mr. Joyner tried to submit to establish how the scheme operated, to establish any reasonable basis to, to show why he believed that the term patient was not false. I want to just point out the question that Judge Thacker referred to.
Can I help? Can you help
do you
me
have any evidence that any of the money that...
Counsel,
I'm
can you
sorry.
help me understand that last statement? That they limited the evidence that would have provided a basis for his belief that that patient wasn't false.
Yeah.
Why would that be true? I mean, imagine you had the CEO who is a man of impeccable honor and integrity, and also a lawyer and doctor and Indian chief and everything else, right? He's the perfect person. The fact that he says patient means X, if Mr. Joyner didn't know about that, why would that legal opinion be relevant in a trial, right? I don't care how good the CEO is. He doesn't instruct the jury on the law. That's the judge's job. And if Mr. Joyner didn't know about it, it obviously couldn't have gone to his state of mind. So I guess I'm just having a little hard time understanding why, even if somehow this evidence was on its face reliable rather than requiring many trials, why it would have actually helped establish some facts of relevance for you.
Well, I would ask you to focus in on what the prosecution's argument to the jury was, which was that these were open and obvious lies that any seasoned medical professional like Mr. Joyner should have known were false. They didn't just say Mr. Joyner knew it was false. They said every seasoned professional would have known it was false. And they said Mr. Joyner was essentially, he was acting on his own against MCS, against his employer, and that he was making these decisions. And if he had consulted Dr. Kevin Smith, who's on these emails, as a supervising physician, he would have told him that it was obviously false that he was the patient because there was not a real-time encounter, right?
Where's the last part of that? So the last part of that, where do I look in the record to see where the government argued that had he contacted Mr. Smith would have told him he was committing fraud?
It's in the rebuttal summation when he says that Mr. Joyner hid the fact that he was, or he basically shielded himself from supervision by Kevin Smith because anybody, and his own supervising physician, because anybody who is a doctor who was looking at this would say that it was a fraud. And so I think the fact that that very person is actually looking at this issue very carefully, actually consulted with the American Telehealth Association about how to define the term patient, and received a response from the American Telehealth Association that says that ATA officially defines a patient encounter the same way that CMS does. Any encounter where medical treatment is provided and/or evaluation and management services are provided.
Do you
This could apply
think
in asynchronous or synchronous
legal
situations.
opinion, do you think that legal opinion, for whatever it is, well, I don't know whether it's right or wrong, that you could introduce that as like evidence of the law?
I think that I can.
No, right?
Well, I'm sorry, go ahead.
No, you go ahead.
I think that you can introduce it as evidence that somebody was provided an alternative definition and somebody reached out to try to find out if there was an alternative meaning, and that there's not one open and obvious meaning of what the word is. So I'm not asking for anybody to accept that specific definition for what the law is, but just that reasonable people can disagree, and that the people at MCS, who he was accused of aiding and abetting, looked into this issue. Mr. Joyner literally did not.
It sounds like he was accused of aiding and abetting them, but then also the government's theory was in part that he hid it from them.
Yes, at the same time.
And the same cannot both, well, those two things again seem somewhat inconsistent to me, but I would like to get back to, you were trying to read a question and answer from the trial earlier.
Oh, I'm sorry. The question, I just want to make clear, the question was, do you have any evidence that any of the money that was paid to labs through Medicare ended up with Mr. Joyner? So it was about it was about the government's funds. That is the question.
Oh, so it was actually about the government's funds and not about the lab funds.
Yeah, through Medicare ended up with Mr. Joyner, and then there was an objection.
But why is that relevant? So the question is whether the $17,000 he received in fungible dollars could be traced to the $3.6 million that was paid. Why would it matter whether the $17,000 that he was paid is directly traceable to the $3.6 million or not? I mean, I have no idea what the relevance of that is. He got $17,000.
Mr. Joyner's in a scheme by himself to defraud somebody. He's got to have an intent to defraud Medicare.
But we know $3.6 million went in. We know $17,000 went out, right? From Medicare, and the jury found that he was paid $17,000.
He was paid $17,000 by MCS, but there was no evidence, because it was excluded, of the relationship between MCS, Christopher White, the laboratories,
or where the funds went, because when appellant tried to ask about where the Medicare funds were traced, the government objected and that was excluded, or the objection was sustained, correct?
That's correct. And then the government also asked questions about who Christopher White was. Christopher White was the mastermind of this scheme, that is this nationwide scheme. And Mr. Joyner tried to ask a question about Mr. White's relationship with the laboratories, and there was an objection. That information never came out. That Mr. Christopher White was receiving kickbacks from the laboratories, and nobody at MCS was. Mr. Joyner certainly wasn't. That was the nature of his elaborate fraud scheme.
Can I just ask you to connect, just so I understand, these objections that you're describing, have you challenged those as like individual evidentiary decisions? Why are they relevant? If I'm writing an opinion, I understand.
I think she just brought, in fairness, I think because I brought that up when I was questioning Ms. Ray, as it just, go ahead.
I just was.
The reason I'm bringing it up is because the court wholesale excluded all emails, all questions about anybody besides Mr. Joyner, and based on this one ruling, excluded any evidence of how the overarching scheme worked. I will just note that the reason I think it's relevant is because the government objected to that question, said objection, relevance, court's prior order, which is the order on the relevance. So they were using this to really rein in any evidence about anybody besides Mr. Joyner, but then they're trying to hold him liable, saying that he was aware of red flags of an obvious fraud that was being committed by other people, including Christopher White. He couldn't ask a single question about Christopher White.
And you think that that you've raised and preserved that argument distinct from the question about the exclusion of the evidence that sort of seems most obviously raised in the brief. You think this separate argument is also raised by your brief, and we should consider sort of this, in essence, this Mallory kind of claim?
I think it's part and parcel of the same, I think, I see it as part of the same claim, so maybe there's a disconnect. But I absolutely believe we squarely raised the issue that he was not allowed to present evidence of the overarching scheme.
Your argument is that I think, as I understand it, is that the exclusion of that, what you say is relevant evidence right before the trial, permeated the trial throughout, because even on these objections that I've raised, the court and the government used the prior exclusion of the relevant evidence as the basis for sustaining those objections. Is that right?
Yes. And the court followed along and said, yes, I sustain those objections. And Mr. Joyner was never allowed to ask questions about Christopher White. Obviously, this extends to the other issue that was raised during Appellee's argument about the exclusion of witnesses. Mr. White was in the courtroom and he was excluded from, or he was allowed to assert the Fifth Amendment, even though he pled guilty to taking kickbacks from the very same laboratories for the very same test that Mr. Joyner was accused of being part of that healthcare fraud scheme. And he was in the courtroom with a lawyer, and he never had to answer a single particularized question about why he would be able to assert the Fifth relating to his overall role in the scheme, when the defense or lawyers said, we just want to ask him about what was in his plea agreement. Because
Ms. Santillo, we've filed this furrow multiple times already. I want to give you an opportunity to say anything you want to say about the three sentencing issues.
Yes, but can I just raise one thing, which is I think that even if people disagree with me out of the Fifth Amendment and the evidence, the government's commentary on that was prosecutorial misconduct that I think further undermined the fair trial, because they knew that evidence was excluded, they knew the witnesses were excluded, and they, at the outset of the government's rebuttal.
Can you talk about the loss amount?
Yes. Well, this is an example of Mr. Joyner being held accountable for laboratories he wasn't allowed to present any evidence about. There's no evidence he had any idea how the laboratories were connected to the scheme, how they billed, what they were doing. So I don't think it's reasonably foreseeable to him in any single way, that they would bill $10 million for these claims. The government, when it was advocating,
I mean, he's like a medical professional, right? That sort of lives in this. It's true. I don't know how much one of these tests costs, but that it seems like to me there is this prima facie idea that like the amount billed is the right intended loss number here. The government did not seek him to hold him responsible for what would be foreseeable for all the other people he saw doing the same things that he was doing. I understand your argument, but why isn't that sort of like the very nature of medical billing?
Well, I think it's important to clarify that Colby Joyner never billed Medicare for anything. His services were never billed for.
I understand you can argue guilt too. That's totally fine.
No, I'm saying
if that's the argument, counsel, if that's the argument, I'm totally fine. So that's good. But do you have an argument that's not about guilt? Right?
I don't think this is about guilt. I think this is about reasonable foreseeability. I think that it makes sense to hold people accountable when they bill for intended loss based on the facial amount of what was billed, because that is their intention, right? It's more closely tied to their intention. But because the laboratories were billing in a separate mechanism that we never even saw what they submitted to Medicare except through the claims data that Mr. Joyner never saw, there's a bigger disconnect between his intentions about the billing than there is in an ordinary case. So that was my point on that issue. when the government was advocating for actual loss, they noted that the amounts here were speculative. They're usually double billing in these cases. And, things may have been processed more than once. They identified potential ways that there could be errors in this data. And so they advocated for a $3.6 million actual loss amount. And they also said fairness.
How about the mass marketing issue?
I think that if you look at the way that the guidelines, I think that we cited the analysis of the Second Circuit, which is in our favor in terms of cabining, basically noting that the fraud guidelines essentially tie victims to the pecuniary loss of the victims in the cases. That's how it's defined. And that is victims of the offense. Here, Medicare was the intended, was the victim of the offenses. And I think that there were also in the cases where people have been held accountable for the telemarketing, they had a much more active role in the telemarketing itself. Like Mr. Joyner was really asked to apply specific criteria. He did. He applied tests that I think, were clear on their face, but he had very little interaction. He was not out mass marketing to people. And so I think his attenuatedness from the actual telemarketing activity also distinguishes him from some of the other circuits that have held that where the defendant himself is using telemarketing to target victims, that the enhancement is appropriately applied. So I think on the law, the term victim is used in the same guideline that the mass marketing is used. And I think that it has a specific context in this case of people who are targeted to part with their money. Here, what the government has talked about is not a pecuniary loss, and I think that there is a distinction under the entire, fraud guideline along those lines, and it makes sense that this would only extend to Medicare.
Very much appreciate it. Did you have anything else you want to say?
No, I guess I just want to emphasize that I think that the evidentiary errors were very much compounded by the prosecution.
We went over those about 3 or 4 times, I think, the evidence issues.
Well, I'm talking about the prosecutorial misconduct and the government's commentary that Mr. Joyner didn't present the evidence so that the jury should give less weight to Mr. Joyner's effort to mount a defense. I think that there's clear law that is highly improper, and I think that was an error that compromised the trial. Even if the court were to find that the evidentiary rulings were correct, it really drew the inference that Mr. Joyner chose not to put on evidence because it would have been harmful to him, when in fact the court excluded witnesses for testifying in light of their Fifth Amendment rights. And, it's well settled. There's a long line of authority that says that's highly improper and prosecutorial misconduct, and I think that warrants reversal too.
Ms. Santillo, I think I can tell you as we conclude that I think your client's been well represented in this appeal. We appreciate your arguments and presentations, as well as those of Ms. Ray, and I'm satisfied that we can take this deal under advisement and adjourn court for the day. Madam Clerk.
Thanks very much.
This honorable court stands adjourned, signed die. God save the United States and this honorable court.
And I might say also, that I should say, that if we were in Richmond, we'd come down and shake hands with counsel and congratulate them on their presentations. And we're unable to do that today because of the weather. But again, we appreciate you.
Thank you, Your Honor.
Thank you very much.
Judges, I'm going to put you into the conference room now.
Thank